All right, let's jump right in. Today, we are tackling one of the most powerful and honestly, one of the most misunderstood tools in any litigator's toolbox, Rule 57, preliminary attachment. Think of it as your legal safety net, the thing that makes absolutely sure your victory in court isn't just a piece of paper.
So, let me ask you something. Have you ever worried about a hollow victory? I mean, picture this. You've spent years fighting a case. You've poured your time, your money, your energy into it. And finally, the court rules in your favor. You've won. But then, what if that win feels kind of empty?
Yeah, this is the absolute nightmare scenario for any litigant, right? You get that favorable judgment, it's all official on paper, but when you actually go to collect, poof, the defendant has sold off all their properties, their bank accounts are empty, or worse, they've just up and left the country. Suddenly, that judgment you fought so hard for, it's pretty much worthless.
And that's exactly where Rule 57 comes in to save the day. See, preliminary attachment is this amazing provisional remedy that lets you basically freeze the defendant's assets right at the very start of the case. It's like the court steps in and puts a hold on their property. You can think of it as a security deposit, really. It's there to make sure there's actually something left to collect when you, hopefully, get that final judgment.
Okay, so how does this whole thing work? Here's our game plan. We're going to cover what preliminary attachment is, when you can use it, how to get the writ, how to challenge it, what happens after the judgment, and of course, some key takeaways and pitfalls for the bar exam. Let's get into it.
All right, first up, the grounds for attachment. Or, when can you actually use this awesome power? Because, and this is super important, you can't just ask for an attachment in any old case. Nope, the law is really specific. You have to prove that your situation fits into one of the very specific grounds laid out in the rules. So, Section 1 gives us what I like to call the 6 gateways. These are the only ways in. As you can see, they cover some pretty serious stuff. We're talking about a defendant who's about to flee the country, cases of embezzlement, fraud, hiding property, all that juicy stuff. And I can't stress this enough, you have to fit into one of these 6 categories, no exceptions.
Okay, let's zoom in on that first one, Ground A. The defendant is about to leave the Philippines. Now here's the kicker. It's not enough that they're just going on vacation. You have to prove they are leaving with the intent to defraud their creditors. That word, intent, is everything. It's the whole ballgame for this ground.
Let me give you a quick example. So, Maria sues Pedro for $1,000,000. Then, she discovers that Pedro has booked a one-way ticket out of the country and is practically emptying his bank accounts. See, it's not just one thing. It's the combination of actions that screams intent to defraud. That is a textbook, slam-dunk case for an attachment.
Now let's jump to Ground D, because this one is all about timing. We're talking about a defendant who's been guilty of fraud in contracting the debt. This isn't about some fraud that happened down the road. No, this is about fraud at the very beginning, at the inception of the deal. The lie was the foundation of the whole obligation.
So picture this. Juan wants a big loan from a bank. To get it, he hands over these amazing financial statements that are completely fake. The bank gives him the money, later finds out about the fake documents, and sues. Now, the reason they can get an attachment isn't just because Juan isn't paying them back. It's because of the fraud he used to get the loan in the first place. That's a really important distinction to remember. Okay, so you've got your grounds. You're solid. Now what? How do you actually get the writ? Let's break down the step-by-step process.
First, you file an affidavit. This is where you swear to the court that one of the grounds exists. And you have to post a bond. This is your "I'm serious and I'll pay for damages if I'm wrong" money. Once you've done that, the court can issue the writ. And here's the really powerful part. It's often done ex parte. That means the defendant has no idea it's coming. After the writ is issued, then you serve the summons, the sheriff goes and physically levies or freezes the property, and finally, the sheriff reports back to the court on what they got.
Now let's talk bonds, because there are 2 you absolutely need to know. First, you have the applicant's bond. The plaintiff files this. It's basically a shield to protect the defendant in case the attachment turns out to be wrongful. Then you have the counterbond. The defendant files this one. It's like a sword to fight back. It discharges the attachment by swapping the frozen property for a bond. So 2 different bonds, 2 different parties, 2 totally opposite purposes.
Okay, but this isn't a one-sided fight. The law gives the defendant ways to push back. So let's flip the script and see how the defendant can defend against an attachment.
So the defendant basically has 2 main options. Option 1 is the fast and easy way out. Post a counterbond. You're not saying the attachment was wrong, you're just saying, here, take this bond instead of my property. It frees up your asset quickly. Option 2 is the direct attack. File a motion to discharge. Here you're arguing that the whole writ was improper from the get-go. Maybe there was no valid ground, or the applicant's bond was no good. This is where you fight it on the merits.
All right, let's hit the fast forward button. The main case is finally done. Judgment has been rendered. So what happens to that property that's been sitting in limbo this whole time?
Well, it's pretty simple, actually. If the plaintiff wins the case, that attached property gets sold off and the money is used to pay the judgment. Simple. But if the defendant wins, not only do they get their property back, but the plaintiff could be on the hook for damages. Remember that applicant's bond? This is where it comes into play. It's a big risk.
Okay, for all my law students and bar reviewees out there, you'll want to lean in for this part. We're talking bar exam pitfalls and tips. This stuff comes up all the time, so let's make sure you don't make these common mistakes.
All right, let's run through these quickly. Pitfall number 1, messing up the timing of the summons. Remember, the summons must be served before or at the same time the property is levied. Get that wrong, the whole attachment is void. Kaput. Pitfall number 2, trying to attach exempt property. You can't just go after a family home or their essential tools for work. Know the list. Pitfall 3, missing the deadline to claim damages. If you're a defendant who won, you have to claim on that bond at the right time. And a key tip to always remember, the attachment can be issued ex parte. That's the plaintiff's ace in the hole.
And it's really important to remember what the Supreme Court has said time and time again. Just because a judge grants a writ of attachment, that doesn't mean the plaintiff has won the whole case. Not at all. It's just a preliminary step. The court is basically just checking if the plaintiff's affidavit looks legit on its face. The real fight, the trial on the merits of the case, that all happens later.
So, if there's just one thing you take away from all this, it's this simple phrase. Rule 57 is how you secure the judgment before you even win the case. It's the ultimate tool to make sure that at the end of the day, you're not left holding an empty bag.
So there you have it. That's how you turn a potential paper judgment into a real collectible victory. Now that you've got a handle on how to secure a judgment, I'm curious, which other provisional remedies should we dive into next? Let me know. Thanks for watching, and stay sharp.